Information required to prepare a will. 1. The full name and address of the testator. 2. The names and addresses of the executors of the will. 3. The names and addresses of all the beneficiaries of the will. 4. A list and particulars of properties owned by the testator and how he or she wants them shared. 5. What should happen in the event of the death of any of the beneficiary or in the event that the gift fails. 6. The place of origin or ethnic nationality of the testator in order to determine whether there is any native law and custom that will restrict the disposition of the property. 7. The religion of the testator to help determine if he or she is subject to Islamic law that will restrict the disposition of the property. 8. Any relatives or dependents of the testator. This is necessary for the purpose of making reasonable financial provisions for them if they were maintained by him. 9. How the testator desires that the residue of his or her estate be shared. 10. The names and addresses of witnesses. 11. Any previous will or codicil of the testator to be compared with the earlier instructions given. A clear instruction should also be taken to ascertain if he intends to revoke earlier wills. 12. Details of persons who may be appointed as guardians of any infant of the testator. 13. Who will be in custody of the will. 14. Provision for remuneration of the executors. Very important, a solicitor should endeavor to receive instructions before drafting a will, and this should be done in the following ways. 1. The instructions should be written and signed by the client. 2. The instructions may be given in the handwriting of the client. 3. Where the instructions are taken by the solicitor, he may ask the client to sign them even before the will is prepared. This is to help in the rebuttal of any allegation of fraud or lack of intention or undue influence. Custody of wills. After executing the will, the original and any counterpart may be safely kept in any of the following places. 1. With the probate registry within the jurisdiction. 2. With the solicitor who prepared it. 3. With the bankers of the testator. 4. With the testator. Advantages of keeping the will with the probate registry are: A. It complies with the requirements of the law, Section 35 of the Administration of Estates Law of Lagos State. The court should provide facilities for safe custody of wills of living persons. B. It ensures safe custody. A person should deposit his own will in the court for safe custody, and an original will shall not be delivered out without the court's direction in writing having been sought and obtained. C. It aids in the proof of the will. And D. It helps facilitate the grant of probate. Formal parts of a will. 1. Commencement. This describes the document and links the maker of the document to his act of making the document. E.g., this is my last will, or this is the last will of me. 2. Date. States the day the will was made and executed. E.g., made this dash day of dash. 3. Revocation clause. This annuls any earlier will or codicil made by the testator and assists in affirming the present will as the last testamentary act of the testator. E.g., I revoke all former testamentary documents or dispositions made by me. 4. Appointment clause. This clause appoints the personal representatives and trustees of the testator. E.g., I appoint dash. 5. Charging clause. This clause permits and mandates the personal representatives and any person or persons acting in that capacity to charge for any services they render, or otherwise their services will be taken as having been rendered gratuitously. E.g., I declare that my executors shall charge, or I authorize my executors to charge. 6. Gifts. This is the clause that bequeaths gifts, legacies, and devices to respective beneficiaries. E.g., I give to. 7. Residuary clause. This clause states the persons who will be entitled to the residue of the estate of the testator. E.g., I declare that the remainder of my estate shall. I give to. 8. Substitution clause. This is necessary and is bound to take care of any gift that fails or ceases to exist at the death of the testator. 9. Testimonial. This links the testator with the will, i.e., in witness of which. 10. Execution and attestation clause. i.e. signed as his last will by the above named testator in our joint presence and then by us in his presence, or signed by the above named testator in the joint presence of us and each other who in his presence and that of each other have subscribed our names as witnesses. The rule in Craddock and Piper. Where the lawyer is representing himself and other executors generally, they are not entitled to remuneration. However, there are exceptions. A. When the remuneration is identified in the will, and B. In the case of a solicitor representing himself and the executors. If the solicitor is representing himself only, he is not entitled to remuneration. Where executors make an application to the court is confronted with two issues. One, generally they are not supposed to be paid. Two, the estate is a complex estate and the time spent by the executors in the administration of the estate is enormous. Ethical issues. 1. A solicitor should draft a will carefully to avoid ambiguity while it is being interpreted. Rule 14 of the Rules of Professional Conduct. 2. A solicitor owes a duty to advise his client as to the restrictions under Islamic and customary laws. Rule 15 of the Rules of Professional Conduct. 3. A solicitor should avoid being negligent in the preparation of a will. If he is negligent, he is liable to his client. 4. A solicitor should not take instructions in his client's house except in exceptional circumstances. Rule 22 of the Rules of Professional Conduct. 5. If a solicitor is the executor of a will, he should ensure that he does not mix client's money or property with his own. Rule 23 sub 2 of the Rules of Professional Conduct. 6. A solicitor owes his client a duty of confidentiality. He should not disclose information that has been reposed on him by his client. This duty is highly required in the making of wills. Rule 19 of the Rules of Professional Conduct. 7. A solicitor should ensure that he follows the instruction of his client and such instructions should be kept in case of challenges with the execution and the reading of the will. The instruction should of course be in written form. 8. A legal practitioner shall not in the course of making a will make secret profits. 9. A solicitor is duty bound to disclose any conflict of interest in the course of discharging his duties as a legal practitioner. Rule 17 of the Rules of Professional Conduct. 10. Where the solicitor is a beneficiary in a will, he should ensure he complies with the rule laid out in Wintle and Nye 1959 1 WLR 284. He should ensure that the testator seeks and obtains independent legal advice and services apart from his. Sample draft. Quick glance note is powered by Rollums and Luxury. your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Connie Close of Inima Crescent, Igbefon, Lekki, Lagos, Nigeria. Tell WhatsApp 08142775425 091569137 and send your emails to ronumsandluxury@gmail.com, Instagram ronumsandluxury, Facebook ronumsandluxury. You can call them for all your real estate questions. For sponsorship and advert placements, please contact 09125921620 or send an email to resistandpartners.chambers@gmail.com.